Justice Blackmun's challenge. Are preborn children persons within the original public meaning of the 14th Amendment? Let's use 3 different tools to answer this question. First, definitions from when the 14th Amendment was ratified. Second, historic state practices related to abortion. And third, the framers' understanding of the amendment. So first, definitions. According to dictionaries of common and legal usage at the time of the 14th Amendment's adoption, the term person was largely interchangeable with the term human being. The 1864 edition of Noah Webster's dictionary defined the term person as relating especially to a living human being, a man, woman, or child, an individual of the human race. No dictionary of the era referenced birth or the status of being born in its definition of person, man, or human being. In legal usage, every human being was considered a natural person. In his Discourse on the Rights of Persons, the authoritative treatise writer William Blackstone wrote, "Life is a right inherent by nature in every individual." For Blackstone, if human life existed, legal personhood existed also. There was no distinction between biological human life and legal personhood. Second, state practice. Centuries of English common law tradition consistently treated abortion as the wrongful killing of a human being. From her founding, the United States adopted this tradition and prohibited abortion as soon as human life could be detected. When the 14th Amendment was adopted in 1868, the states widely recognized unborn children as persons. Nearly every state had criminal legislation prohibiting abortion, and at least 28 jurisdictions labeled abortion as an offense against the person. 9 of the ratifying states explicitly valued the lives of the preborn and their pregnant mothers equally by providing the same range of punishment for killing either during the commission of an abortion. Furthermore, at least 10 states considered abortion to be either manslaughter, assault with intent to murder, or murder. In 23 states and 6 territories, laws referred to the preborn individual as a child. In fact, the same Ohio legislature that ratified the 14th Amendment called abortion, at any stage, nothing less than child murder. Thus, at the time of the 14th Amendment's adoption, nearly every state understood person to include prenatal life. Third, the framers' understanding of the amendment's legal application. The framers expected the 14th Amendment's guarantees of equal protection and due process would apply to every member of the human species within U.S. jurisdiction. Senator Jacob Howard, who sponsored the amendment in the Senate, declared the amendment's purpose was to disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property without due process. Even the lowest and most despised of the human race were guaranteed equal protection. As Justice Hugo Black later put it, the history of the 14th Amendment proves that the people were told that its purpose was to protect weak and helpless human beings. Considering this evidence, it is clear Roe v. Wade was wrongly decided. Preborn children are constitutionally entitled to due process and the equal protection of the laws. The Constitution, properly interpreted, prohibits abortion under the 14th Amendment, and every constitutional officer who swears an oath to uphold the Constitution has a duty to ensure those rights are protected.